Muy buenas tardes. Nuestro siguiente panel de esta tarde es, el tema es conflictos de derechos en obras audiovisuales, de la libertad de expresión al derecho de imagen,
which will be moderated by Toñánez. The video, please. Conflict of rights in audiovisual works, from the liberty of expression to the rights of image. And highlights Taylor English from the USA. Patricia, Renjifo, ECIJA, Colombia. Moderator, Raquel Toñánez. Ortiz, Asociados, Paraguay. Good afternoon, everyone, to those brave ones who are with us today. We have a very interesting panel today. I'd like to share that one of our speakers will be speaking in English in case you want to make use of the real-time translation. Our subject today is very interesting. The right to privacy of the image in most of our countries is a constitutional right, as well as the freedom of expression, although of course with certain limitations, because it can in no way be degrading others. And so those limitations, we have to understand when to ask for authorization, when not, at what moment, when we would have to let publications take place, where those would take place. We'll begin with the first panelist, which is Patricia Renjifo, Associate of Intellectual Property and the Right to Entertainment, Startups, Innovation, and Entrepreneurship of this firm in ECIJA, Colombia. She's been recognized as one of the best lawyers on media and entertainment rights for specialized publications, with 16 years of professional experience in media rights, and associate to the biggest producers in Colombia, and providing services for platforms such as Netflix, Amazon, Apple, Telemundo, Spotify, Deezer, among others. Patricia.
Esto. Hola, hola.
Hello. Perfect. I wanted to see this full, but I understand. I don't know if we'll see the... Okay, perfect. So basically the idea of this conference, and I would like this to be as interactive as possible, because obviously we have strong competition with the soccer game. We'll begin with the subject of why it's important to analyze the rights to image and other rights with which there may be a conflict in an audiovisual work. Basically, here I have an infograph of the Mary Institute team, where you'll be able to observe what items must usually be revised, ideally, before beginning with filming, basically in the scripting phase. Obviously, there's the script, music, journalistic archives analyzing brands, and the real or image rights. Why is it important to analyze this in the development phase? Because as we begin in recording, obviously there are parts here connected to audiovisuals, and this can begin to impact those rights, and it will be more expensive to reverse this in post-production. In terms of names or image rights, this extends to everything that has to do with the voice, with aliases, similarities, the afro of the pibe, the shoes of Michael Jackson, anything that is distinctive to the person that references their rights. These rights in Colombia, as Raquel mentioned, are protected under the Constitution because they're related to the right to intimacy, but also to a good name and reputation. And it is also considered personal data, so there's a double protection taking place. And every time we speak or talk about these rights in audiovisual productions, and this of course has an impact on freedom of expression. And I want to mention several cases here. I think you're all experts here and know what those possible conflicts are when I'm going to talk about a real story. Now, of course, when we talk about audiovisual work, there isn't just one type. There are fictional works. There are fictional works based on real-life events. There are biopics. There are documentaries. There are fictional or hybrid documentaries. And that's why I said in the first infograph that the legal work of clearance begins from the script. And it begins by understanding what our script is all about. And this obviously has to do with the relationship between lawyer and client and the creative interests of the client. Here, when we ponder rights and the rights of image versus creative freedom, we need to know what that creator wants to tell us or wants to share and how we can mitigate risks. Because we won't talk about annulment of rights. Whenever there are rights of image, there's a risk of a claim. It'll never be zero. So basically, it's a matter of mitigation. So here I can show you our projects, the projects that we've worked on from the firm. And I think it's interesting for this to be more interactive and not so theoretical. Mi Encuentro con el Mal is a docu-series. It's a fictional docu-series based on possessions, demon possessions. And this is a complicated subject because we can imagine where we would find archive images where there are people there. It has a fictional component. And how do we inform the audience of what they're seeing? How do we handle these rights? In this case, given the connotation of the subject, the legal recommendation was to obtain the image releases. And the image release can't just be a one-pager where I say, I authorize the use of my image for an audiovisual work. No, I have to state what the purpose of that is, the description of the piece, so that I might know what is the use that will be given to my image, especially in the case of this audiovisual work where it's a theme that could impact the right to intimacy. And so here, when obtaining releases from all of these people, and not just the owners of the file, but of the people who appear in the work, understanding that they had the vocation of appearing in an international platform and that this would be seen in all territories around the world. This is very important when authorizing these rights. You can't just have a general authorization. It's important to know what the purpose is. I'll explain more. The second is a documentary, 100%. There's no fiction involved about the Colombian select team, or basically understanding that we use the logos and emblems of the teams. Evidently, there was a need to sign authorizations and many of the challenges that we came across. And here we have to address the exception of Law 23, where if I'm in a public space like a stadium or a concert, I'm authorizing the capture of my image in a way. We had a lot of discussions about the people who appear in the stadiums. And so we had to have the releases of the people in the stadium, right? But no, that's absolutely impossible when we speak of football. And so we basically make use of that exception. Of course, we're talking about Colombian law. It's important to understand this, or look at it from this perspective. This exposure talks about the conflicts that exist between the rights to image and other rights like freedom of expression within Colombian legislation. And this will be interesting with Amanda because it'll give us the input from the United States. And what's interesting for these types of productions, although the clearance happens from a Colombian perspective, these are works paid for by American companies. And so there's a matter of applicable laws here. What are the risks that can or cannot be assumed when treating image rights? But with this documentary, this is a tribute. It speaks well about the select team. There is no disrespect or impact on the reputation of the people who appear in it. The worst that could happen is that they might lose a game, or the things that can happen in a game but there isn't a judgment or a personal attack on any of the individuals. And so in this particular case, the strategy that was used to mitigate or minimize the risk of conflict was to obtain all of the releases of the people who appeared, especially those interviewed and the people who had a greater presence in the piece of work or in the production. And when I talked about the people in the stadium and the marches, there were people singing along the streets of Bogota. So we make use of the exception contemplated by Law 23 of the use of image when I'm deciding to leave the environment of the private and be present in a public event. And then fictions based on real events. Rebelión is a fictional movie inspired by Joe Arroyo, a famous character, a salsa singer who has passed already. This is a movie that, although it is fictional, is based on events that are publicly known, based on different types of research. And basically, why did we go with this recommendation? What we've done, aside from revising the applicable law, we look at the jurisprudence of the Constitutional Court, and the Constitutional Court in Colombia has carried out a lot of analysis with regards to these conflicts of rights, and it's very interesting, which I'll share later on. But basically what the court says in one of the last verdicts is that if I have the events, if I can prove that what I'm saying in the movie happened and that it's published in other forms of media and is public knowledge, I would not be affecting the rights to intimacy. Another important fact that I mentioned at the beginning when we looked at the infograph was the matter of brands. Joe Arroyo is a registered brand, and so a registered trademark, and so in order to protect a piece of work, knowing that we're going to use real names, is to try to obtain the most of intellectual property that we can when licensing the brand or the trademark. And basically, with this type of fiction based on real events, the riskiest component, regardless of these two examples, is fiction. And it is what happens if I request a release from the living person or negotiate with those inheriting or from people who've passed away. Because it's important to mention that in Colombia, our right to the image does not extinguish with death; it persists. And as an inheritor, you can, under the violation of fundamental rights, like the right to reputation and intimacy, you can begin or file a lawsuit in order to remove a piece from circulation or communication to the public. In Colombia, there are several cases like this, Operación E and Mariposas Verdes. But it's interesting that the court, in these rights, the analysis that's been done has prioritized freedom of expression and creative freedom, because also fictionalization, as has been said, what's been said by the court is that first we have to inform the user or the spectator, and so this is a story based on real events, the characters are fictional. These types of disclaimers won't necessarily annul the right.
But eventually, these are disclaimers that allow the user to have an information in terms of what they're seeing is not an authorized biography, is not exactly what had happened. And will give them the possibility to have a position in terms of what they will be viewing. Another interesting topic that the Constitutional Court of Colombia has done is to take into account the will who wants to see this audiovisual work. The disposition is public in all the territories and all languages, but I decide what I want to see. And obviously, I go more towards the creative freedom, but obviously the work of credence and the analysis of audiovisual works that have these components start taking the analysis of this subjective topic. And one of the speakers yesterday, I believe it was interesting because they said that there was no sentence or court sentence that is exactly objective, because the judges always have a level of subjectivity, right? That depends on their position, their growth, their positions, and their way of contemplating life, and that influences their sentences. And obviously there are two fundamental rights that are confronting at the moment of analyzing the right of image versus the right of free speech, and we include their intimacy and the good name. is looking if that right to use the image of that person implies an infringement or a damage. And the court has made an interesting analysis with the topic of the damages, and they made a checklist of questions in one of those sentences where they tried to prove if effectively there was a damage or not. And they spoke about the 3 stages of the individual. It's similar to what they handle in the United States. And the question is, well, it would be nice to talk about this, but for example, we now have a case where the image rights were obtained in a generic release for an audiovisual work. In the beginning, just for research purposes, to be able to have better knowledge of the facts that will be told in this audiovisual work. But throughout the development, as some of you might know, in these kind of works, in the development, like in series or movies, can take 3, 4, or other years, depending on the script writing and other factors. Nowadays, there's an interest of talking with real names, that the characters of the series use the real names of the people that were interviewed. At the moment that they were interviewed, they told them that it would only be for research purposes. And they told them the idea is to use your real name. The release is the same thing. The release talks about the authorization of the image right. They talk about the possibility of bringing fiction to the facts. They talk about everything. But which is my personal perspective? My personal perspective is that they're missing that element of how that right of image will be treated. And that's where we go into one of the real critical topic in the conflict of rights. If I tell a person that I will be using his real name or her real name because I will be talking about a public fact, and I tell them that I'm going to be telling their personal story, but I will be able to bring some fiction into it, the person, of course, will say, okay, how are you going to bring the fiction into the story? What is that character going to be? So you start in this conversation in terms of what level of fiction or those dramatic elements, because sometimes real life is more exciting than fiction. But you know that when you're writing a script, or you're writing the script of a soap opera or an audiovisual production, it needs to have drama. What happens if in the middle of this fiction I invent or suggest that one of the people had an extra or had a bad relationship with another person while they were married? And there are cases that are more subjective than others, but the court has said that if they vulnerate the right of their image in a way that they cannot socialize with other people and it affects their relationship with others, that's where we would be in a severe case of the violation of your image rights. And what happens if I say that they were bad playing football? I could say, no, I think it's not so severe, or that it affects their image rights. But if I say, okay, they were professional football players, that's where we have to go and start analyzing once again. What could be declared as a defamation? It has to be something that is turning or twisting the perspective of that person, of the person, and it's something that comes into the light not only of the court but also day by day in audiovisual creations, because here probably we won't be talking only about the rights but ethics. In the speech that I made some years about the ethic of the filmmakers going outside of the legal risks is how much do you tell your characters what are you going to do with that release? And another thing that I would like to say is that in Colombia you have the right to give a step back. You can give a step back from that authorization you gave if you of course pay for that. If I have a protagonist that gives a step back in all his right, they will need to receive of course some money, because a production is also costly. I brought this example because I wanted to talk about brands. Some months ago we had a juridic consultation about Pablo Escobar, and what we found is that the Superintendency of Industry and Commerce has denied registering some brands of Pablo Escobar due to the good manners and the public image. But his brother has an international portfolio of brands, and he has Pablo Escobar registered in different countries around the world. And the question that came out when we made that analysis was, if this person has this portfolio of intellectual property and brands or trademark, could this person oppose or not to the exploitation of the name or the exploitation of the brand in the audiovisual work? One of the conclusions that we attained in this specific case is that the nature of the work, well, it was not a movie, it was a comedy. They mentioned him, but he was not the protagonist. It was not a biopic. Because if I make an authorized biography, what I really want to ask there is to have an access of information at first hand, an access to filed photography, the access to information that I only have and I want it to be exclusive. In that sense, the releases will go amongst these lines. So it's very interesting in terms of the brands. When I have a trademark or a portfolio of intellectual property that is related with a real person, up to what point or not can I stop an audiovisual production that is exploiting this person? Another important element in light of this dilemma and this debate is the type of character. The kind of character. Obviously, the law won't give the same protection to a public character, to the public news, to public facts than a common person in his intimacy. So the conclusion, at least in Colombia, in terms of the status where we are, in terms of pondering the rights that could be in the exploitation of an audiovisual work, and I talk about exploiting, because in Colombia you cannot stop a movie in terms of the infringement of an image right. I cannot get to the production and say, hey, stop everything because there is a possibility of violating an image right. Obviously, it has to be a topic that involves communication and conversation. So it's a topic that goes from case to case, and that's why it's important that first infographic that I showed, this rim of Cleveland, applies for each one of the audiovisual works where you need to analyze from the script which will be the context of the usage of that image right. That's why it can not only been done through a synopsis or through a general description of the project. You have to read it completely and carefully. When you read it this way, you will be able to find globally which is the image that I'm giving, which is the portray that I'm giving to this character, and if effectively or not there will be a risk of having a claim. The claim risk will never be able to be mitigated. I will never be able to annul it. No, I will be able to mitigate it, but not annul it. Because in the sense that I'm talking about a real person, I have that risk of going into their personal intimacy. When we talk about a previous consent and releases, obviously what I was mentioning is that, in my opinion, and further than the legal side, there's the ethical part of up to what point I should communicate to this other person how I'm going to be using their image right, or their name, or the name of their parents, or the person that they're representing at the moment of the signature. Obviously, here it also has to do with the destination. If they tell me, for example, Patricia, can I record your speech in ASIPI? I said, yes, of course, record. But if I go to YouTube, I say, okay, it's from the framework of ASIPI. But if they extract this part and put it into a movie, obviously no. They overpass the authorization I gave over my image. And if additionally that movie talks about migration or something that could affect my reputation, we would start going more in deep in the possibility of that action of claiming. The other element that I mentioned is to see if there are rights of intellectual property, books, literal work, to see that chain of rights. If I have the intention of making an authorized biography and I have the intention of making a movie based on real facts, I could examine if there are trademarks that I could or not, from where I could or not obtain a license. If there are movies or literature that have already exist, to be able to obtain the rights to make an adaptation. That will not annul the risk, but obviously if I obtain the rights of a novel, where in the novel we already had this story of love or the affair, or an affair, and I have the rights of that book that was already read, has prizes and recognition, and there is no really a claim over that literature, obviously we won't annul the risk, but we will lower the risk to be of receiving a claim over this audiovisual production. The right of expression and creationship, then the fact check when we're creating a documentary, something that we need to do not only from the legal point of view, but also to mitigate the risk and from the perspective of ethic. If I'm going to be telling the user or a spectator that what they will be seeing is a documentary about over a public fact, the hijacking of an airplane, an accident, the explosion of a volcano, for example. The most important element to credit is that effectively what you're telling is true, and it makes part of that fact check. From those elements that I am informing the spectator that happened have journalism support, or it has a support enough to be able to accredit that that's real. And not only a support, it should be at least three publications that I could find that fact happened in the way that I want to communicate it. In the scenario of the documentary, it has to do with the good faith. And that's why I was mentioning at the beginning, what kind of audiovisual work are we treating? Because the legal treatment won't be the same. It's not the same to have a fiction based on real facts or a complete fiction that brings together elements of a love story or a treason. When I have a hybrid work where I use part of fiction and part of reality, the spectator should know it at the beginning, especially in the framework of a documentary, understanding that what I'm telling the public that happened, especially when I'm talking about people, and this is a key factor in cases where we already have a lot of series and audiovisual works produced in Colombia. If I'm going to be talking about a legal case, I need to be sure that I am effectively having an access to the real file, and I'm gathering the facts as they happen. I can bring some fiction, but I cannot say that there was a sentence due to homicide when it didn't happen, or I can't say that that person, aside of being accused of murder, he also had some other kind of crimes in his shoulders. I have to take a lot of care over what was sustained in sources in terms of what I'm bringing into fiction, and that is the thinnest line in terms of claims. In the sense that I obtain or release towards the image right, I use distinctive elements of the person, but I also say that I'm going to be bringing fiction, that I will introduce new characters, that I'm going to alter the timeline, that I will incorporate new elements, and those new elements being a dramatic turn in the audiovisual production could not generate any kind of effects, because we're going into the field of how subjective things are. What kind of fiction, even if I feel affected, that's something we were talking with Raquel, could I consider that affected me in my deepest side of interaction with my family and society? That part of the fiction that they did with my image right, but probably for the Constitutional Court, it could be a subjective topic that didn't affect all the different lines of the individual and makes part of that artistic creation and the freedom of creation and speech. I believe this is a case-by-case topic. There's no specific outcome. It's a topic of analysis, but it's interesting to debate this in these kind of spaces, because the Constitutional Court has made an interesting exercise in the last cases we have seen, and I believe that as attorneys of entertainment, we will always be confronting this when we're assessing an audiovisual work, and it's how do we protect the producer and also the individual that is giving this permission, this authorization for his life to be reflected or portrayed in that series or movie. That is it. Thank you very much.
Gracias, Patricia. Excelente presentación.
Thank you, Patricia. Excellent presentation. I believe it's very clear that this is very subjective. And now I want to present the next panelist, Amanda. Elena's
A commitment to providing pragmatic, value-driven strategies. Her areas of focus include trademark and copyright enforcement and litigation, trademark clearance, and portfolio management. She also draws on more than a decade for experience handling media issues to counsel media companies, authors, journalists, advertisers, and filmmakers on liability avoidance and dispute resolution in publishing. Amanda, please.
Hello? Hi. So this presentation is going to have a surprising amount of overlap with Patricia. I'm amazed at how much our legal framework is so similar in the United States. I'm going to talk a little bit today about what that looks like, focused on individual torts and kind of how the US courts look at these torts. So the three big ones, and there are other ones that may come up, but the three really big ones are misappropriation of likeness, invasion of privacy, and defamation. And in terms of US law, you know, why should you care? Why would it matter? Well, you may wind up being dragged into court into the United States on a variety of jurisdictional reasons. I will put all of you to sleep if I talk about jurisdiction for more than 10 seconds, so I'm going to keep it pretty short. But if you have done any filming in the United States, if any of your film concerns a US resident or an estate of a US resident, there may be grounds to come into court into the United States and to wind up with liability under US law. So the first topic I'm going to talk about is misappropriation of likeness. This is also often referred to as your right of publicity. This is your right in your image, your name, your voice. It can be a variety of things that are associated with your being, who you are. And it's state by state specific, so each state has its own codification or common law on how this is treated. So it isn't necessarily going to be exactly the same analysis in every court in the country. But there's a lot of overlap, there's a lot of commonality. One of the really big issues right now that's changing dramatically, even in the last 2 or 3 years, is whether there is a right of publicity in a deceased person. So can an estate bring claims related to use of the image or likeness of a deceased person? The historical answer to that was no. Always no. And if you look at jurisprudence going back anything more than about 15 years ago, it wasn't possible. But we've had a lot of very effective lobbying on the part of some celebrities' families, and it started in California, and now we're seeing it trickle into other states, where an estate actually can initiate an invasion of privacy for right of publicity claim based on use of the image or likeness of somebody who has passed. That is particularly important state by state, right? So if you have a situation where you want to use the likeness of a person who has passed, the very first question you're going to ask is, what state did they live in when they passed? And then the whole analysis flows from there. And there can be a lot of litigation over that very question. Jimi Hendrix is a great example. We had, I don't know, 4 or 5 different states involved in trying to answer questions about who had the rights to his likeness. And cases were filed in one state, and then when that didn't work out, his family went to another state to try to initiate the same exact claims under their laws. So the jurisdiction of state versus state can have an enormous impact on how these kinds of cases turned out. So very closely related to misappropriation of likeness is the concept of invasion of privacy. And again, this is state by state. There is no federal law that governs this. Generally, this is the idea that you have some right to privacy over your most personal and embarrassing things in your life. And so if you're going to do any kind of documentary or even just a journalism piece, and you have juicy information that someone had an affair, or they have a sexually transmitted disease, or there's a skeleton in the closet, as we say, you need to be careful, and the alarm bell should be going off that this could potentially result in a claim for invasion of privacy. In order to have one of these claims, though, you have to have a reasonable expectation of privacy. So if the person has already put this information out there somehow, some way into the public, it is inherently not private. So if something is on Facebook or Instagram, it cannot be the basis for a claim for invasion of privacy. Usually where these claims come up tends to be with secret recordings, where someone has put a camera somewhere or some kind of recording device, and someone didn't appreciate that they were being recorded either in film or just audio. Again, the states on that vary widely. Some states are two-party consent, which means both parties to the recording have to give permission for it to be recorded. Other states are one-party consent. So If you're interested in doing a secret recording for purposes of a film, you've got to check what state you're in. So these two claims are very related. They both fall under a big umbrella of claims for invasion of privacy, and they have very similar defenses. And so consent and legitimate public interest, these are the two big defenses. And I know Patricia talked a lot about consent as well. We're coming right back to it. Releases. If you have a release from the person you are talking to, giving your consent, then it's highly unlikely that they have a valid claim for invasion of privacy or misappropriation of likeness. That consent needs to be real. It needs to tell the truth about what it is you're going to do with the information they give you. I'm going to talk at the end of this presentation about some real examples, including one case that completely fell apart because even though the filmmaker got all of the consents, those consents didn't really portray the true nature of what the project was going to be, and the court wound up throwing out the consents as void. Public interest or newsworthiness. This is the other huge, huge exception, and this is what gets everybody out of trouble in the United States. And it's a pretty low bar. Courts tend to find that something is newsworthy for pretty much any reason, including things that are just pretty salacious, honestly. I mean, there's a lot of cases involving celebrities, and if it touches on a celebrity, it doesn't really matter what it is, it's probably considered newsworthy. So if you've got any of these news values at play, odds are good that you have a newsworthiness defense to a misappropriation of likeness claim or an invasion of privacy claim. So invasion of privacy is directly tied to celebrity. I think I just mentioned this, but I have a whole slide on it. The more famous a person is, the harder it is for them to claim invasion of privacy, the harder it is for them to claim that something about them is not newsworthy. So if we have any sort of documentary involving a famous person, and I'm going to show some examples about that too, these types of claims just don't work in the United States. Courts are always going to find that there's a legitimate public interest in talking about them and that therefore they had no expectation of privacy. So in order to avoid these types of claims, we've got some best practices. Get consent if you can. You might be able to use someone's likeness without consent anyway, but if you can get consent, that's a really good starting point. If you're going to get consent, don't misrepresent the project. Don't misrepresent the scope of what you plan to do with this person's likeness. And if you're not going to get consent, if that's not possible, then you've got to ask yourself, is this really newsworthy? Is it in the public interest? Am I talking about things this person has already put out there or that's already public knowledge in some way? And have I gone overboard? Have I taken something and really embarrassed someone in a way that probably wasn't necessary for the film's value? Courts do like to look at that, and a lot of times you'll see in decisions that a court will say, okay, well, they used what was necessary. They couldn't tell this story effectively without borrowing in this way. So, kind of a quick little checklist there. So defamation and false light are looked at very differently under US law. They're kind of sitting in one bucket with the invasion of privacy claims in the other bucket. These claims are incredibly hard to win in the US. We have so many different hurdles to get over. So if you are a plaintiff trying to sue for defamation or false light, your odds are very, very low. I spend a lot of time at work convincing people not to file these lawsuits because they don't work. But theoretically, we do have these laws on the books, so it's worth talking about. One of the big things, we're talking a lot about docudramas and fictionalized works based on real events. We've had a lot of litigation over whether something actually concerned the plaintiff. So someone's going to bring a lawsuit, they say, well, this story was about me. Well, what if that character didn't have their name? right? It was a composite character loosely based on this person's life. We see that a lot. So one of the very first questions that comes up is, does the public appreciate or understand that this composite character, this fictionalized character, really is supposed to be this other person who exists in real life? If that connection, if that nexus does not exist, the claim is dead. We need to also appreciate the fiction versus nonfiction element. Patricia talked about this also. If you have a work that is clearly labeled as a work of fiction, even if it is based on true facts or based on historical events, you're not going to succeed in a defamation or a false light claim. So you will see, you know, in all of Netflix is very good at this, you know, this is a fictionalized account. This is based on true facts, but it's not real. Those kinds of disclaimers are incredibly important, because without those disclaimers, if the public perceives that something is supposed to be entirely historically accurate, it can open the door to these types of claims. And then we have actual malice. So public figures, meaning someone who is known to the public, they have an extra hurdle, which is this thing about me that was false? Was it done basically with intent? It's almost that level of standard. It has to be not just that you were negligent or you didn't fact check well enough, but you almost have to have a vendetta in a way against this person. It has to be malicious and deliberate in order for a public figure to succeed on a claim of defamation or false light. And so, as you can imagine, a lot of litigation is typically focused around whether or not this person is a public figure, right? That's not always a binary question. There's a lot of gray area there. And we also have a concept for a limited purpose public figure, which is an individual who isn't famous, but they kind of get thrust into fame that they didn't ask for because they're at the center of some sort of controversy or public event. Richard Jewell is a really good example of this. He was the individual who was accused of bombing Atlanta's Centennial Park in 1996 prior to the Olympics, and he was eventually cleared of all charges, and it turned out he didn't do it, but there was a lot of press, and every major news organization in the US was talking about him. He was a nobody before that happened. And so, of course, he claimed he was not a public figure. Ultimately, he was held to have been a limited purpose public figure because everything happening around him was so newsworthy. So even he, as a private individual, had to prove actual malice. So one of the concepts that we see in docudramas and fictionalized things a lot is, do the viewers understand that it's fictionalized? Courts look at the consumer's perception, the viewer's perception. And if the viewer believes it is fictionalized, defamation claims probably aren't going to work. I pulled this quote out of a court case because I think it kind of just says it in a very succinct way. But viewers are now very accustomed to fictionalized history, and they don't expect the networks and the producers to follow history perfectly. We all know how boring that would be. And so US courts are incredibly sympathetic to media defendants who take liberties with history because viewers understand that it's not real. So I'm gonna walk through some cases that we've had in the US recently. This one's one of my favorites. This was it started off as a book, and then it got turned into a very successful movie. But this was a real life story about a fishing crew that went out to sea, and they got caught in a very terrible storm, and the entire crew perished at sea. And the book was very successful, and then the movie came out, and the movie took a lot of liberties, especially with the main character who was the captain of this ship. And in the movie, he was flirting with women who were not his wife. He made many missteps on the boat that arguably were inferring that he could have done more or done a better job to save his crew at sea. And of course, who knows? Who knows what happened out there? They didn't come back. So all of this had to be imagined. And his His wife sued the filmmakers, claiming that this was all misappropriation of likeness. She couldn't sue for defamation because he was deceased. And that is, I should have mentioned that is consistent in all 50 states. You cannot defame the dead. So what are you left with in this situation? Misappropriation of likeness. This case went on for years in and out of different courts, but eventually was completely dismissed because of a commercial purpose issue specific to Florida. Again, these are state-specific cases, and this particular case was brought in Florida. But under Florida's misappropriation of likeness rules, there was not a sufficient commercial purpose. In other words, there was a newsworthy purpose to the film. Even though the film generated lots of money, that's not really what the statute intends, right? It's not that kind of commerciality. This one's based on a Lifetime movie. This is the Romeo Killer one. So this lovely fellow was an actual axe murderer. He is sitting in life sentence in prison, and Lifetime made a movie about him and took lots of liberties according to him with the story and the facts of all of this. And so he sued Lifetime. And again, public interest, newsworthiness defense applied. I also think this guy was sort of defamation proof and misappropriation of likeness proof. I think there's always something to that. When I have clients, I always want to start with making them as human and warm and fuzzy as possible to the court, and I don't think he had any way to present himself in a sympathetic manner, and so I think this was doomed just because of who he was. This one's a little bit more recent. This is the Get Your Consents Correct story. So this was a Netflix series in which they took a look at some folks who were hypochondriacs, people who always think that they're sick and they're terrified of germs and that sort of thing. And Netflix actually got releases from all of the individuals that were depicted in this particular series. The plaintiffs wound up filing suit anyway, despite these releases, on the basis that they did not understand that the series was going to present them in such a negative manner, and that they had been misled about the subject matter of this particular series. And it turned out that I can't remember exactly what the topic was that they had been told the series was about, but it definitely wasn't this. They had no idea that this entire series was going to make fun of them. And so they filed suit. This one actually settled pretty quickly. The court threw out the consents at the very initial stages of the case and said that the consents were not valid because of the misrepresentations that had been made. And then the case settled and went away. I think this is a story of not only get your consents right, but I think they would have won this if they kept going with it. I just think there were probably economic reasons that it didn't make sense to keep defending it. Okay, here's another one. I've got a quick video. This works.
Katie Couric is taking responsibility for a misleading edit in her documentary Under the Gun. In the film, Couric talks with members of the Virginia Citizens Defense League about the ease of obtaining a gun. In the actual interview, members of the gun rights group respond quickly to Couric's question, but that's not what's represented in the final edit. Take a look.
Let me ask you another question. If there are no background checks for gun purchasers, how do you prevent felons or terrorists from purchasing a gun?
Couric is now apologizing, saying, "When I screened an early version of the film with the director Stephanie Sachtig, I questioned her and the editor about the pause and was told that a beat was added for, as she described it, dramatic effect, to give the audience a moment to consider the question. When VCDL members recently pointed out that they had in fact immediately answered this question, I went back and reviewed it and agreed that those 8 seconds do not accurately represent their response."
So here the only claim was that the editing was bad, right? That these guys wound up looking like they didn't have an answer to the question, when in fact they had all promptly answered the question. So they filed false light claims in Virginia, the $12 million case at the time, claiming that this edit to the footage falsely portrayed them as not having an answer. That case was thrown out immediately on its face. Court said the footage does not on its face carry the defamatory sting required. In other words, this judge did not believe that that editing really changed anyone's perception of these individuals who filed the lawsuit. So what does all of this mean? Liability is unlikely, but lawsuits are expensive. So a big part of our job as counsel is to avoid these lawsuits in the first place, not because we think we're going to lose them, not because there's a high risk of liability, but they're a hassle, they're expensive, they're really bad PR. You don't want to have to deal with it. So our job is to figure out what can we do on the front end to make those lawsuits very unlikely. Get releases where you can. It's always important to get a release if you can. Don't misrepresent your project when getting a release. I lost my slides. There they are. Thank you. Okay, so if your work is fictionalized, make sure you tell your audience that it's been fictionalized. These types of disclaimers are critical. They tend to work. Living people, be more concerned about those than if you have a deceased person that you're talking about. If you do have a deceased person, pay close attention to what state they resided in at the time of their death, because that can be outcome determinative as to what kind of claims their family is able to bring. And just like any good journalist, ask lots of questions, keep lots of records. You know, if you've got someone you've interviewed for a particular story and you can't corroborate it, they don't have any documentation, that's really risky. You're putting your entire case on one person's story that they've told you. That's probably not a very good practice. You have to imagine, okay, if we get into court over this, how am I going to defend this? What am I going to point to that I did a reasonable job doing my fact collection? And if one person, potentially with a lot of bias, gave you a story and that's all you had, it's not good journalism and it's not going to turn out well with your documentary either. And of course, talk to U.S. counsel. Get advice up front, especially as you can see, a lot of these laws are very state specific. Someone in the U.S. can help you navigate exactly what state's laws are going to apply and whether those laws are going to get you out of trouble or not. Again, it's very, very challenging to bring successful cases on any of these publication torts in the U.S., but the real liability is in the hassle. It's in having to deal with these things, having these kinds of stories on CBS. It's very embarrassing. So really, a lot of this is the PR, the financial expense, much more so than it is a concern over actual liability at the end of the day. That's it.
Thank you, Amanda, for a very good presentation. Vamos a abrir un momento de preguntas. Tenemos 10 minutos.
We're going to take a moment for questions. I think we have 10 minutes. Juan Felipe. Mi pregunta.
For moderating the panel. How do you feel you mentioned lobbying and how celebrities are lobbying for changes in legislation? Are there anything that we need to worry about what's coming in terms of what they're aiming to in the U.S. legislation? And Patricia, do you feel like the same in our countries? Like there is a need to regulate something? I need to, or should we stay as we are, just with the general case law discussion? Thank you.
Thank you. I think we're going to continue to see states adopt post-mortem rights of publicity, one after another after another. There's a lot of general consensus, I think, that the use of someone's image to create a lot of money without compensating their estate is wrong. It's morally wrong. And I think the public perception is that it's fair and it's just and it's right that the estate is able to continue to capitalize on that. And so, the 23 states or so that have already passed this legislation happen to be the states where most celebrities live. So Florida and New York and California, and, Illinois, all those states have those kinds of laws. I think the only reason they don't exist nationwide is because a specific issue in a specific case hasn't yet come up to cause the estate of someone's family to go argue for these kinds of laws in that particular state. I think the minute it happens in any particular state is when you're going to see the law change there, and we'd have eventually probably 50 states, maybe not Alaska. Nothing ever happens in Alaska.
Gracias, Juan Felipe. Pues creo que la
Thank you, Juan Felipe. I think the question is very interesting. Whenever we find a new production and we start to do that work, at least in what has to do with image right in Colombia, we respect authors' right in terms of protections, and so in terms of times and risks for claiming, I think there's a large risk, and whenever we do clearance work and during development, I'd like to have more clarity in terms of the rules of the game, especially for what Amanda indicates, because it's not for defamation reasons. People who have passed away in the United States, I think there's a risk here. Even if we win the process, we've seen absurd claims sometimes, and it's so challenging. So it would be great to have development on that end. And there's something in particular that I'd be interested in. It's the subject of the documentary. We've been told that for documentaries we don't apply those exceptions for newsworthiness or access to information, but we have documentaries where it would be interesting to see regulations for those types of contents, because when we go look for the releases, obtaining releases for a documentary that is kind of a whistleblowing content or political content, it's almost impossible. And so it seems like censorship, basically, because of the difficulties that are present when it comes to getting those kinds of releases. So I think there should be specific regulations to documentary in Colombia. That we need protection in order to do these, or to produce this content with more freedom, of course not violating anyone's rights, but without having to necessarily request information to mention someone, because it's like getting censored before you even make the content. A couple of last questions and we close.
Bueno, muchas gracias a las tres. Muy interesante la conferencia. Yo quería...
Thanks to all of you. It's been very interesting. I've seen a bit of an intersection between your right of publicity and your image rights and authors' rights. Lately, I've seen cases in the United States where a photographer takes a picture of a celebrity, and then the celebrity in their social networks publishes that photo, and then the photographer sues and wins a case. There's an interesting intersection there between the right to my image and author's rights or intellectual property. Do you think there should be an exception in terms of these rights where we should prioritize the right of image as the celebrity's rights? Because I do think there's a discussion to be had around this. Even if you're okay to take pictures in public spaces, I guess it's the hypothesis isn't necessarily that the photos are taken in private contexts, but I wanted to ask you if you have any opinions
I think what you're asking is the conflict of rights between copyright and the right of publicity. In the United States, we have the copyright trumps all, right? So if you're the copyright owner of a photograph or any other type of work, you have the ultimate right to decide what is done with that work. And so yes, there are cases where the subject of a particular photograph absolutely consents to the photograph being used in a certain way, but if the individual photographer didn't grant rights, then that photograph cannot be used. And it's big business in the United States right now for professional photographers to sue over use of images. And celebrity photographers, the paparazzi type photographers, really lead the charge of this. You know, the images get picked up often quite innocently, and often because they are newsworthy and used, and these photographers will say, you didn't have a right, and then they extort far more to settle the matter than they ever would have charged to use the photograph in the first instance. Many of these cases probably would result in a loss to the photographer if they actually were to litigate it all the way through, because there is a fair report sort of privilege under copyright. When we look at fair use, one of them is it newsworthy, and did you have another alternative photograph to use? And so if the answer is it's very newsworthy, I couldn't get the picture anywhere else, it's probably fair use. The problem is the economics of that case typically don't justify the actual defense of the claim. And so the media companies, especially the ones I represent, we tend to just, it's a tax. It's a cost of doing business a lot of times, just to pay the money and move on.
En aras de la discusión, José, yo creo que yo estaría de acuerdo más por el lado.
Now, for the sake of discussion, I see it more the way you see it in terms of the exception. And I think this goes hand in hand with what Juan Felipe talked about, the regulation in terms of the right to publicity. There are matters that have to do with fundamental rights and privacy and patrimony, but I think it would be good to have more development in Colombian law to understand the limitations. I don't think there is, or I think those types of cases in Colombia aren't so common with respect to paparazzis, those kinds of things. I haven't seen them very much in the Colombian context. I think the right to image connects with copyright. We have debated the subject of tattoos, for example. Understanding that when I get a tattoo, I'm owner of my own image. I shouldn't have any limitation in terms of presenting myself with a tattoo. I don't have to request authorization from the artist, right? And so I think it's interesting for right to publicity to be considered below that of auth or copyright. I think it would be interesting to develop these things, since in Colombia we don't have fair use. We have certain exceptions, and I think it'd be interesting to develop these kinds of things. Patricia, last question, and quickly, please.
Muchas gracias. Voy a tratar de ser.
Thank you. I'll try to be very brief. Some months ago, I was surprised by the news that Bruce Willis had sold his right to publicity for future projects, for him to be represented through artificial intelligence or something like that. And later, some weeks later, it was revealed that this was false. But this raises some thoughts. To what extent could this actually be done? And even as a Star Wars fans, I remember the movie Rogue One, where Carrie Fisher, Princess Leia, was represented, her image and her voice, but she had already passed. And so I don't know, what is your perspective on these possibilities for virtual representation through the use of artificial intelligence? I think there are contract matters. As far as I've been able to understand those rights of publicity, to even to that extent. And there's the documentary by Anthony Bourdain, where they falsify a voice, where through technology they were able to develop entire sentences with his voice, which to a spectator it's impossible to know what is and isn't him. And this has an impact on not just your rights to publicity, but the statements that are said, and it's things that he never said. It is literally to put words in someone's mouth. And even though he never said anything defamatory or something specific that we might highlight as problematic, just the fact that the spectator, the fan, could watch this and not know what he didn't say is to enter a very interesting universe in terms of your rights around that kind of use. In the case of Bruce Willis and artificial intelligence, I read on the subject of contracts, to what extent within a contract for services, when I work with a franchise like Star Wars and I give them my rights to interpretation, to what extent am I providing them or giving away my rights for a specific purpose? But if I'm going to pass away, I won't have that ability to authorize or not something. Or in the case of the Bruce Willis idea, I understand there's a prohibition in Colombia where we have a limitation for future rights or to negotiate things for the future. There's still a dilemma there. But I think we're going to have to debate these things on whether they're contract matters or is it something that we should turn into law in order to clarify it for everyone.
We got all of that. Can you repeat his question in English?
Fabri, ¿podría repetir la pregunta en inglés?
Could you repeat the question in English? Fabri, we're going to carry a microphone over there because
Repetí, Fabri, así el auditorio te...
Can you repeat, Fabri?
Actors like Bruce Willis can share the deep fake image right after their death to use with artificial intelligence for future productions.
Yeah, that's fascinating stuff. My cousin runs bars in Nashville, and including some really big ones that can accommodate thousands of people. And at one of these bars, they actually have holograms of deceased country music stars. They're behind the bar, and it seems like they're actually making drinks for people. So like Johnny Cash or Elvis will make drinks behind the bar, which is so incredibly cool. But it raises these issues. And I think, in that instance, these kinds of uses, I think, got grandfathered in under the old misappropriation of likeness standards when estates really couldn't control so much of the imagery. But I don't have a strong view on what the boundaries there should be, right? I mean, because I think really what you're talking about is contractual. It's how far should you be able to contract for things that happen after. Because Bruce Willis, did he contract for that to be after he died? Yeah, I would imagine that that's really a question of contract law and ethics, but it sure does open up a lot of really interesting possibilities for holograms and things like that. So my personal opinion is that we would love to see more of that to make these kinds of things possible for the fans. Fans love to see this kind of thing, and I hope we can keep doing it.
Ok, bueno, damos por finalizado este panel. Agradecemos.
So we conclude this panel. We thank Patricia and Amanda for excellent presentations. We thank you for participating this afternoon here, and thank you.
Muchas gracias. Vamos a salir al coffee break y volvemos a las 3:20.
We will return at 3:20.